everyone. Good morning. My name is Sylvia Soltis, and I'm a senior staff attorney at Legal Aid in the Pro Bono program. Thank you for joining us for today's webinar representing tenants in housing conditions cases. We're thrilled to have you with us. I'm joined today by my colleagues Jody Feldman, managing attorney at Legal Aid, Samantha Kashgarian, senior staff attorney in our housing law unit, and staff attorney in our housing law unit, Eleni Christides. Eleni will be leading us through this presentation. A few quick housekeeping items. We are recording this training, so I am asking that you please take this opportunity now to mute yourselves if you are not already muted. If you have questions throughout the presentation, please type them in the Q&A box. We're going to be monitoring that box throughout the presentation. Before we launch into our presentation, I want to share just a little bit of background about Legal Aid, especially for those of you who are new to us. We are DC's oldest and largest civil legal services organization. We were founded in 1932, and we like to say that for over 88 years, we have been making justice real in individual and systemic ways for persons living in poverty in the district. We are primarily an in-house organization, with the vast majority of our work being individual casework, though we also do systemic advocacy. Our direct client representation is in 4 substantive practice areas. Our housing law unit focuses primarily on eviction defense, though today, as you know, we're going to be turning our attention to housing conditions cases. We have a domestic violence and family law unit where we help DV survivors secure protection and custody orders, as well as obtain child support. Our public benefits law unit helps clients obtain safety net benefits that help them make ends meet and to which they're legally entitled. These can be food stamps, unemployment insurance, healthcare, TANF, disability benefits, and the like. We have a consumer law unit that focuses on foreclosure prevention and debt collection. We also have an appellate practice that handles appeals on a broad range of poverty law issues. Finally, we have several small cross-unit projects, such as our immigration project and our reentry justice project. All that is to say that we do a lot in-house, but our pro bono program allows us to significantly expand our impact by providing legal assistance and representation to hundreds of additional individuals and families in DC each year. It is through our partnerships with attorneys just like you that we were able to help serve more people in DC. So with that, I want to say thank you for your interest in helping and for joining us today. I'll now turn it over to my colleague, Eleni Christides. As I mentioned, Eleni is an attorney in our housing law unit. She represents low-income tenants in eviction and housing conditions cases before the DC Superior Court. Eleni has and is an expert mentor to pro bono attorneys who take on housing conditions cases. So you may find yourself, if you take a case, you may find yourself paired up with her. There you go, Eleni.
Thank you, Sylvia. Hi, everyone. Good morning. Thank you so much for joining us for this training webinar. Today, we're going to talk a little bit about the background and origin of the housing conditions calendar, talk about what it's like to take a case that is referred by Legal Aid, represent a client, and see them through the process of litigating in the housing conditions calendar, and end with just a couple notes, tips on remote court proceedings and how to best represent your client when we live in this remote world still. As Sylvia mentioned, we have a Q&A button at the bottom that you can put questions in, and they will be answered hopefully by Sylvia, Sam, or Jody while I'm speaking. And if need be, they'll flag the question for me and I can address it in the presentation. You can also put a question in the chat, and that would be visible to all the participants of the webinar. So with that, I think let's get started. Sylvia is going to be pulling up. Yes, I see it. Thank you, Sylvia. So starting off with just a little bit of background on the housing conditions calendar. This is a specialized calendar that is the product of sustained advocacy by legal aid and other civil legal services organizations in response to a problem. And that is that there was not really a forum where tenants could appear pro se and get effective recourse when their landlord was not maintaining their housing up to the code, the housing code. So in April 2010, after some sustained advocacy from legal aid and other stakeholders, the court developed the housing conditions calendar. And it was designed to be a very pro se friendly forum where tenants could bring a case for seeking repairs to their housing. Prior to the creation of the housing conditions calendar, there was not a lot of recourse for tenants. A tenant could choose to withhold their rent and to sort of pressure their landlord to make repairs that way. But of course, by doing so, they were essentially inviting the landlord to sue them for eviction for non-payment of rent. So it carried a lot of risk, and it still does if tenants choose to withhold rent in an attempt to get their landlord to make repairs. Another option that a tenant had was just to file a normal civil lawsuit in the civil actions branch of the court. But of course, that process is very slow and is not the best way to get quick repairs made especially when you're dealing with sort of emergency issues. And it's not particularly pro se friendly. It's complicated and not intuitive. And it would also force a tenant to essentially bring all possible claims that they might have arising from the conditions in their housing. So the housing conditions calendar was designed to be more accessible by not requiring tenants to bring the universe of all claims that they would bring against their landlord, but really just focusing on current conditions and current repair needs and the relief of the landlord actually making the repairs, so injunctive relief, and not other forms of relief such as damages. And it's been somewhat successful, and it's been a lot more accessible to tenants. However, there are still challenges, and especially during the pandemic, it has been very hard for people to navigate how to file a case and how to effectively litigate a case on their own. So that is where you all come in. We have seen a very dramatic decrease in the number of housing conditions cases filed by tenants during the pandemic. But we know that people are still living with serious housing code violations and that they need an effective means to redress them. On top of that, hearings being totally remote and inspections also being largely remote has made it very challenging for tenants to effectively advocate for themselves. So we are really relying on you all to help people in our client community navigate this process and get some relief from serious housing code violations. So if you are able to take a case referred by legal aid pro bono, I want to talk a little bit about what that will look like and how you'll get started with the client. So of course, meeting with the client is the most important first step. When you get a case referred, you'll have the client's contact information, and you'll have a brief description of the case. So we really encourage you to reach out right away, introduce yourself, kind of tell them who you are, and clarify your role and what they can expect out of a housing conditions calendar case. Obviously, what they can expect is for repairs to be made, but you wouldn't necessarily be helping them recover any kind of monetary damages. Especially now when it's a lot harder to meet people in person, many people are still working remotely. You'll want to be very thoughtful about how you communicate with your client and take into consideration their preferences, their work schedule, their level of comfort with technology, whether they prefer phone calls, text messages, emails, and sort of navigating that relationship from the get-go and building rapport with them. So once you've connected with the client, you'll want to start your investigation, determining what are the conditions in your client's home and what are the repairs that need to be made. So we really encourage people under normal circumstances to meet in person and to do an in-person visit to the client's home, take photos, bring a colleague or an assistant to take photos and take notes of all the conditions. Obviously, that has been a lot more challenging during the pandemic. So we have had to get creative. And some people have taken different approaches. There are different approaches you can take. So you can ask a client to send you photographs of the conditions in their unit and supplement that with a very detailed phone call where you talk about each of the conditions and sort of ask, is there anything else? Some people might choose to use an app like FaceTime to do a virtual tour of their client's unit if they can't meet in person. Of course, with more people being vaccinated and the risk going down, we still encourage you, if possible, and if your client is comfortable, to go and meet in person, because it's the best way to really get an understanding of what the conditions are like. In addition to talking with your client and visiting their home, other sources of information about existing conditions in their home or past citations for past violations could be an inspection report by the Department of Consumer and Regulatory Affairs, DCRA. DCRA is the district agency that is charged with enforcing the housing code, and they do conduct inspections and they do cite landlords for violations. So you can rely on any past DCRA inspection report that your client may have as further evidence of the conditions and further evidence of the landlord's awareness of the problem. Sometimes if a client has a subsidy, such as a voucher administered by the DC Housing Authority, they may also have a copy of an inspection report conducted by DCHA that you can use as further evidence. If a tenant has not yet notified their landlord of the problems in their unit, or maybe they've notified the landlord of some problems, but not everything that you discovered through your investigation, the next step you might want to take is drafting a formal letter to the landlord that lists out the issues. You can kind of organize them by part of the home or part of the apartment and communicates to them your intention of filing a housing conditions case and your request that they make the repairs right away. I want to make a note here that it's important not to get bogged down at this stage. I think a lot of people spend a lot of time trying to make sure that their list of the housing code violations in their client's unit is thorough and is thoroughly researched. But it's important not to sort of slow down at this stage, because what really helps you put pressure on the landlord to actually get the repairs made is filing the housing conditions case. And as I'll explain when we talk about filing the case and filling out the complaint, it's okay to be over-inclusive or maybe slightly under-inclusive, because ultimately the court has its inspector who is going to conduct her own inspection, and that is going to kind of form the framework for litigating the case. So once you've done a good faith investigation, once you've drafted a letter, please go ahead and file the case, because that's really how you can get the ball rolling and actually get the repairs made. So just a quick note on relevant legal authority. I've been referring to the housing code, but really in DC, there are sort of two sources of legal authority that govern the sort of standard of habitability for residential housing. There's the DC Housing Code, which is Title 14 of the DC Municipal Regulations. And there's also the DC sort of adopted version of the International Property Maintenance Code. And these two sources of authority largely overlap, but don't overlap perfectly. DC has been transitioning to the Property Maintenance Code, but both are still in effect. If there's ever a substantive conflict between the Housing Code and the Property Maintenance Code, the latter, the Property Maintenance Code, prevails. But as I said earlier, you don't want to get, yeah.
I'm sorry to interrupt. Someone's asking on the chat what tips you have about locating the proper landlord or owner.
Oh yes, we'll get to that shortly. I can give you some guidance about that. So I was just saying that where the Property Maintenance Code and the Housing Code substantively conflict, the Property Maintenance Code prevails. And both of these sources of legal authority will be in the materials that you're given once you accept a case. So we'll provide you with all of that and you can refer back to it. A quick note on a special issue, which is mold. Unfortunately, mold is a very common issue that we encounter with people that we represent or that we refer for representation. Technically speaking, mold is not a violation of the housing code, although issues associated with mold are, such as dampness, leaks, or damage to surfaces. DC passed a mold law and associated regulations in 2014 that outline what steps a landlord must take to identify and safely remediate mold once they're notified of the presence of mold or suspected mold in rental housing. So if mold is a concern to your client, you'll want to notify the landlord right away in writing about the mold, reference the mold statute and the associated regulations, and make sure that depending on how kind of extensive the mold is, that the landlord is using a licensed mold assessor and a licensed mold remediator to address the mold. I'm going to pause briefly just to see if there's a question. Okay. So this actually takes me to the point that was raised, which is identifying the proper defendant and going ahead and filing a housing conditions complaint. So we encourage people to name the record owner of the property as the defendant. And the way to figure out who that is to search the DC Real Property Tax Assessment Database. So this is a database maintained by the Office of Tax and Revenue, and that should identify who the record owner of the property is. Of course, your client may also know who they identify as the landlord. Sometimes that person is like a natural person, but the property is actually owned by an LLC. So you can use that information in conjunction with the tax assessment database to kind of figure out who the landlord is. We also encourage people to identify and name as a defendant a property management company if the landlord uses a property management company to manage the apartment or the building where your client lives. And we encourage people to sort of name both, because sometimes it's possible that while the property management company in practice is the one that is actually going to be having their attorney appear in the housing conditions calendar and sort of be in direct communication with maintenance staff to actually accomplish the repairs, if the landlord should midway through the case decide that they want to switch property management companies or something like that, which has actually happened to me in one case, you still have named the landlord, who is the legal owner of the property, as a defendant, and the case can keep progressing without necessarily needing to wait to substitute the proper defendant. So once you've identified the proper defendants, you'll want to fill out the summons and the complaint. And these are forms that are available on the court's website and that we'll also provide to you when you refer to case. So first, with the complaint, as I said, this is a form. So it's something where you can just sort of fill in the blanks. The PDF of the complaint can be a little finicky, but if you have any kind of normal PDF editing software, you should have no problem. If worse comes to worse, you can always print it out and fill it in by hand. But there are spaces on the complaint, as you can see, for the plaintiff's information, for the defendant's information. The spaces are a little small, so if you run into trouble, you can always sort of add an addendum or clarify that there's an additional party and include their information. When you fill out the summons, you'll fill out a summons for each named defendant, so you can also include the address information for the, if there's a second defendant, you can include it on the summons. The first page of the complaint, as you can see, has boxes to identify how the landlord was put on notice of the issues. It's enough for a tenant to have complained, in person or by telephone. Of course, if you end up sending a formal letter, you can check the box for that. The second page of the complaint, which is on the screen now, is sort of a check the box list of many, though perhaps not all, the potential housing code violations that someone might encounter. So you can use this list as a very good guide, especially when you're interviewing the client, to kind of go through and think, what are all the possible housing code violations that they're experiencing? But as I said, it's not, the whole universe. So you should feel free to liberally use the space for other to include any other additions that aren't sort of covered by these pre-populated categories. And I just want to make one more note about the first page of the complaint, which includes a space for the complaint to be notarized. So our best practice and our recommendation is that you actually have the client sign the complaint, because it is a verified complaint. So the client is verifying the facts and allegations in the complaint. During the pandemic, the court has not been really requiring notarization of the complaint, just because of the difficulty of people meeting in person and restrictions on that. So you don't really have to worry so much about getting the complaint notarized. It should be enough for it to be signed by the client. And it seems like there's a question, so I want to give a chance if there is something. So I do see a question about how long does the landlord have to respond or remediate after the formal letter before filing? So there's no kind of set, there's no set time limit. And actually we encourage you to not wait necessarily for a formal response before filing, because the way that housing conditions cases go is if and when all the repairs are made, either to the satisfaction of the court or to the satisfaction of the client, the case can be dismissed, and there's no need to sort of progress forward. So if you issue a formal letter to the landlord, you can say, these are the issues, we're requesting that you repair them quickly. If everything is fixed before the initial hearing, we'll dismiss the case, no problem. We don't want people to sort of get bogged down again at that stage of having issued the formal letter and then waiting and giving the landlord a lot of time and not kind of putting the pressure of having the case in court. And the reason for that is that we find that there is often a very long delay between the period of filing, the time of filing of the complaint, and the initial hearing. And then there's an even further delay between the initial hearing and the inspection date. And then there can even be a further delay between the inspection and the next hearing, where the court is actually learning what the conditions are. So to actually get the repairs made as quickly as possible, we encourage people to file the case right away, because there's already going to be a built-in delay, potentially several weeks, maybe even more than a month, before the court is hearing about the issues and really looking to the landlord for, putting some pressure on the landlord to make their repairs. So now I'm going to turn to another form that you'll probably want to fill out with your client as you file the case, or as you prepare to file the case, and that's the IFP application. So IFP stands for Informa Pauperis, and it's the status that the court gives to a litigant who demonstrates that for reasons of a financial hardship, they should not have to prepay court costs or filing fees. Many of our clients qualify for Informa Pauperis status, and if someone receives certain types of public benefits, and that includes Medicaid, they can qualify and check the box for one of these presumptive categories that qualifies them for Informa Pauperis status. Some judges may ask for more information. So if you fall under one of these presumptive categories because you receive public benefits or Medicaid, you should not have to fill out the remaining part of the application that asks about your income and your monthly expenses. If someone doesn't fall under one of the presumptive categories to qualify for Informa Pauperis status, then they will have to fill out information about their income and their expenses, and the judge will sort of look at what those, what their income is and what their expenses are, and determine whether they qualify, because it would be a financial hardship to have to pay court costs and fees. So we encourage people to go over this application and fill it out with their client if they qualify, because to avoid paying a fee for filing the complaint, you'll want to have this form ready to submit to the court at the point that you're ready to file the case. So again, during normal times, this could all be done in person, and you could have the court review the IFP application at the point that you're ready to file everything. Because everyone is working remotely, and that includes the court, Now, what you have to do in order to get the IFP approved before filing the complaint is you email it to a special email address called, it's like civil e-filing at dcsc.gov. This is all sort of in the materials that you'll be given. And then the IFP is supposed to be reviewed by a judge, and you should get a response that will then allow you to file the remaining initial filings through the court's e-filing system without having to pay the court fee for the filing. There might be a processing fee, which is very nominal, that you have to pay, but you won't actually be charged the normal filing fee that the court imposes, which I believe for a complaint, if I'm not mistaken, is $15 and $10 for every motion that's filed. So we've been instructed, and we instruct anyone who takes the case for us to send these filings to this email address. It's been a little bit uneven, the response time and the kind of consistency in responding to filings that are emailed in through this email address. So it's a good idea to, if you have not gotten a response within 1 or 2 business days, to follow up by email to make sure that the filings have been received and the court is reviewing the IFP application, and they'll get back to you about that promptly. So another consideration at the outset of the case is whether it's appropriate to file a TRO. A TRO stands for a temporary restraining order, and it's something that you would file if your client is experiencing a really urgent housing code violation. So this is something like, a basic utility like power or water is not functioning, or if it's wintertime and there's no heat, or if there is only one bathroom in the whole unit and the toilet is not working. So there's just a basic facility that is not functioning, and that they can't really be in the housing accommodation without that basic facility. At the same time that you file a TRO, if you decide to file one, it's a good idea to also file a motion for a preliminary injunction, because a TRO is supposed to expire after 10 days. So you'll want to file the preliminary injunction, motion for preliminary injunction at the same time to make sure that even after the TRO expires, that there's still some way to ensure that the urgent condition is addressed. If you file a TRO, you would email it to that same email address I was discussing earlier, and it will be reviewed by what's called judge in chambers. And this is a part of the court that is set up expressly to address urgent filings such as TROs. And if the judge is prepared to hear the TRO the same day or maybe the next day, you should get an email from the judge's law clerk saying, we're going to have a hearing on this. Please let your client know to be prepared. So when you're filing a TRO, you want to have that in mind and anticipate that there might be a same day hearing, or there might be a hearing the very next day on this urgent issue. So accordingly, before filing a TRO, you should make a reasonable effort to notify the landlord of the condition, and first try to get them to repair it. And if they refuse, or they're unwilling, or you're not able to get in contact with them, file the TRO. And it's important to kind of try to make initial contact with the landlord, of course, about that issue, because if and when the hearing is set for the same day or the next day, you'll want to notify the landlord of the hearing so that they can have a chance to participate. I'm going to pause there again just to see if there's any questions in the chat or in the Q&A box. Oh, I think someone is asking about the email address. So I'll just type that in the chat briefly. But this is all the type, this is information that will be included in the materials that you're sent when you, oh, thank you, Sam, when you take a case pro bono. So I want to talk about service. So best practice is for you to make sure that service is effected on each named defendant in the case. Technically, under the court rules, if someone has IFP status, the court is supposed to assist them in effecting service. However, what the court is required to do is simply to mail what's called a notice of acknowledgement form to the defendant. So it doesn't necessarily guarantee that the defendant then signs the form and returns it back, acknowledging that they've been served. So we encourage attorneys to effect service on their own and also file an affidavit of service with the court showing that service has been effected. Service and effecting service is governed by Civil Rule 4. If a defendant is a corporation, you would serve their registered agent, and they're supposed to maintain a registered agent in DC. And this is information that you can find on, again, DCRA, the Department of Consumer and Regulatory Affairs website. They maintain a corporations database where you can find the registered agent for a corporation that is operating in DC. And the rule for service for the housing conditions calendar is that you must serve a defendant at least 8 days before the initial hearing and file an affidavit of service at least 3 days before the initial hearing. So once you've filed a case and you've effected service, then you'll have the initial hearing. And it's actually a pretty straightforward thing. The court will basically want to talk about 3 things. First, was the defendant served or have they waived service? When can we schedule an inspection of the tenant's unit by the DCRA inspector? And when are we going to come back here to discuss the findings of that inspection? So when you take a case, it's possible that you will sort of be entering the case after the initial hearing or maybe just before the initial hearing. If so, you'll just want to enter your appearance to put everyone on notice that you're representing the tenant in the case. But if you are attending the initial hearing, these are the questions that the court is going to kind of want to address. With respect to the DCRA inspection, so that's usually set maybe 2 or 3 weeks, between 1 and 3 weeks after the initial hearing. Primarily during the pandemic, these inspections have been virtual inspections where the inspector will ask the tenant to use either FaceTime or Google Duo, basically an app by which they can have a live video call with the inspector, use the camera on their phone to sort of take the inspector on a virtual tour of their home and point out the conditions and the housing code violations that they observe. Things are sort of shifting back now to where it's more, it's possible to have an in-person inspection. So especially if your client is not the best with technology or they have some other need that makes it hard for them to do a virtual inspection, you can request that the inspection happen in person. And this is also true if maybe the conditions that they are complaining of or that they have are kind of hard to portray by video and really need to be seen in person. You should attend the inspection either virtually by kind of calling into the same FaceTime call. The inspector will have a way to make sure that you're on the call. Or if it's happening in person, attending in person, wearing masks as necessary or appropriate. If your client is going to opt for a virtual inspection, it's really good to do a sort of a practice run with them so they can feel somewhat confident, familiar in what they're going to be doing with the inspector and get used to using their phone to sort of show the conditions to the inspector and kind of troubleshooting that with them, doing a dress rehearsal before the actual inspection. After the inspection, the inspector will issue her report with her findings and her recommendations within usually a few days of the inspection itself. And this report is sort of what's going to form the framework for the remainder of the case in terms of what the court considers the housing code violations to be and how the court analyzes what has and hasn't been repaired. So they're going to use this inspector's report. So it's a good idea when you get the report to look it over carefully, make sure there aren't any errors or things that are sort of inconsistent with what happened during the inspection. Maybe, the inspector pointed something out during the inspection, but she inadvertently omitted it from the report. It's good kind of to look the report over and point this out right away if you notice that something was inadvertently omitted. So once this inspection has happened, what happens? How does the case progress and how does it resolve? So after the initial hearing and the initial inspection, the case will sort of consist of a series of status hearings. The Housing Conditions Court only convenes on Tuesdays, so the status hearing is always going to be on a Tuesday. When the status hearing is scheduled will depend on how quickly the landlord is addressing the issues and how maybe extensive the issues are and how long they're going to take to remediate. Maybe 2 weeks is a pretty quick turnaround. And with the way that the court has been scheduling status hearings, it appears that the court's calendar is sort of filling up. So it might be more the case that the status hearings are 3, 4, 5 weeks apart just because of that scheduling. So in between status hearings, it's very important to check in with the client on a regular basis to determine what steps are being taken, what progress is being made. If there are any issues, maybe a repair is being done, but it's not being done in a very workmanlike manner, or the client notices that the repair that was done is already sort of starting to fall apart itself. So it wasn't done very well to begin with. So you want to be in touch with your client to understand what's going on and what still needs to be done. And if something was done improperly, what needs to be kind of corrected. Similarly, you'll want to be in contact with the landlord or with their attorney to kind of discuss the progress of things and to ask them, when certain things are going to be done, to let them know when repairs are not being made, to kind of keep pressure on them to get the repairs completed. Sometimes issues can arise with landlords complaining that a tenant is not granting their maintenance staff or their contractors access to their unit. This is a very common refrain. So you'll also want to kind of be involved to make sure that your client is actually being given the proper notice that they're entitled to under the law. So reasonable notice for a landlord to enter a tenant's unit to conduct an inspection or to conduct repairs is 48 hours written notice in advance of the request for of the entry itself. So you'll want to make sure that the landlord is actually adhering to that notice requirement and giving your client an adequate advance notice of when they're planning on coming in. And if there's actually like an issue with the tenant not wanting to let the landlord in for any reason, of course, you want to talk with your client to understand what their hesitation is or what the concern is or where the miscommunication is happening to kind of try to resolve that issue and make sure that things are progressing smoothly. If you're finding that things are really not getting done, you can, of course, email the attorney for the landlord to raise the issue with them in writing. You can send photographs to the DCRA inspector assigned to the housing conditions calendar, kind of pointing out issues with some of the repairs or noting that things have not been repaired yet, and do this sort of sufficiently in advance of the next status hearing so that she can review the photographs and, if need be, kind of communicate them to the judge or the law clerk so that the judge is aware. If it's a really kind of, if the landlord is really not doing anything, if they're really not taking any action, you may consider filing a motion asking for the court to impose a sanction on the landlord for not complying with essentially the court's expectation that they follow the recommendations of the inspector and making the repairs in a timely way. And the most common kind of sanction that the court would consider imposing is a rent abatement. So they'll look at what rent the tenant is being charged and sort of maybe reduce the rent that they're expected to pay, or eliminate the rent that they're expected to pay, not so much to compensate the tenant for the conditions that they're experiencing, but really more as a sanction on the landlord for not making the repairs in a timely manner. So the court kind of looks at it as a sanction, not so much like as an award of damages to the tenant. And if that happens, you'll want to make sure that any rent abatement that's imposed by the court is very clear as to what the amount is, when it starts, and how long it lasts, so that if in the future the landlord claims that the tenant didn't pay rent for this period of time, you have a very clear record of the abatement having been awarded by the court as a sanction, and there is no real dispute about why the tenant didn't pay rent for that period of time. And the last thing, of course, if all the repairs are made, then what's sort of typical in the housing conditions calendar is that the plaintiff, the tenant, will dismiss the case. It can be a dismissal without prejudice. You don't have to say all repairs have been made. You can just file a precipice saying that the case has been dismissed. Or sometimes at a status hearing, when the parties are meeting with the court and everyone is sort of in agreement that the repairs have been made, then the court can dismiss the case on those representations. It's not common at all for there to be any kind of trial or final judgment in the housing conditions calendar. The court sees it as a quote unquote problem solving court. So from the court's point of view, when the problem is solved, the case can just be dismissed. There's no need to issue a final order. I see a question in the Q&A about whether tenants should continue paying rent while the case is pending. And yes, they should continue paying rent while the case is pending, because there's no guarantee that the court is going to award an abatement. Of course, it's very understandable if someone feels that they need to withhold rent, but probably the best advice to the tenant is to continue to pay rent. But if this is a situation that arises, you can of course always ask your mentor, your expert mentor, about what to do in those types of situations. I don't see any other questions, so I'm going to go ahead and talk briefly about some tips for virtual hearings. So as I mentioned earlier, it can be a good idea to share any photos that you want to bring to the court's attention in advance. If you want the inspector to sort of see them and give her opinion about whether or not the repairs were done in a workmanlike manner or whether or not something has been repaired, you can email photos to the inspector sufficiently advance, and of course CC the opposing party on that email. An important thing about virtual hearings is to kind of know when and how your client is going to be participating in those hearings. So the court conducts hearings over WebEx, which people can access using a laptop or a cell phone, using the WebEx software or through their browser. And people can also call in just using a normal phone. They dial a phone number and enter an access code. So you'll want to talk to your client about what way they feel most comfortable with joining the court proceedings. Also, if there's any need for an interpreter, you'll want to kind of talk to your client about how they're going to participate if they're going to need the assistance of an interpreter. Something else you want to think about is how you're going to communicate with them during the hearing, because of course, if you are not in the same room with them, then you'll want some sort of confidential channel of communication. What I found can help sometimes is if they're on the phone, but they're able to text you if they have a question or they have something that they want to say, but they're not sure about speaking up in the court. That way they can text you silently without and do it confidentially, and you can make sure that you understand where they're at, and if there's something the question that they have or something that they want to say. It's also good to kind of prepare your client in terms of what they can expect the hearing to be like and how they can expect it to go. Usually the way that most status hearings go is that the judge will just sort of turn to one or the other party and say, what has been done? Where are we at now? What else needs to be repaired, and kind of what else remains to be done for all the repairs to be completed in this case. I see a question in the chat. Okay, I'll get to that in a second. Thank you so much. In terms of virtual hearings, again, it's good to have sort of your key points ready to go because it's such an awkward medium that sometimes you have to just kind of have what you're going to say ready and be prepared to jump in. And to that end, you kind of want to get some comfort with having your notes, whether they're physical notes or on your computer, sort of side by side with the web platform. The court kind of expects and instructs parties to join 5 minutes in advance of their scheduled hearing, but you may end up waiting a little while if other cases are still sort of on the calendar before yours. So you'll just wait until your case is called. Typically, people leave their video cameras off while they're waiting, but then when their case is called, they can turn their video on and turn their microphone on. And another tip that judges really kind of expect people to identify themselves before they speak to kind of create a clear record and make it clear who's speaking on behalf of whom. So I see the question about sanctions. So I was talking about sanctions a couple slides ago, and someone has a question about what if the person has a zero rent obligation because they have some sort of subsidy or they live in subsidized housing. So I think you can fairly ask for a sanction, even if the tenant pays no rent. It might get a little complicated, and I've seen some questions raised. To the extent that the sanction is meant to be to put some kind of pressure on the landlord, I think you could ask the court to impose a fine. But this is sort of a unique situation, which again, it might be good to talk through with your pro bono mentor on the case. I think now would be a good time to pause for any additional questions that folks may have, or maybe that I've missed in the meantime that have been in the chat. Well, keep them coming because we still have a little bit of time. But I will just say that a lot of we do offer resources to folks who take cases, and the main resource that we offer is a manual that contains a lot of the information that I've presented in this training, and just tips and kind of guidance on how to file a case and how to work with your client and how to litigate a case successfully. Of course, when legal aid refers a case, we'll always assign a mentor to you, so you can definitely reach out to that person whenever questions arise, or if you just want to kind of make sure you're on the right track. We're more than happy to answer questions and to talk to folks about their case.
Eleni, there is a new question in the chat that I think.
Yeah. Got it. Thank you, Jody. So I'll just make a couple quick notes. So of course, the DC Courts website has a lot of the forms that we've discussed today and just general information. And if you are at a law firm or at an agency or organization where there are other people who have taken on cases like this before, of course, you can always turn to each other for advice. So I see that the question, let's see. Oh, this is a great question. So what's sort of the interplay between a housing conditions case and a possible landlord-tenant case, so a case for eviction? Do tenants file housing conditions case while an eviction case is pending? What about a retaliatory eviction suit filed post-housing conditions case? So the way that the court approaches cases where there's landlord-tenant case filed first is that a tenant cannot file a housing conditions case second. So if the landlord-tenant case has been filed and the tenant is raising defenses based on housing code violations, the court wants those issues to be litigated in the landlord-tenant case. I think that if you file the housing conditions case first, it can proceed. And I think also if the landlord-tenant case is not related in some fashion to housing code violations, maybe it's based solely on a lease violation, then in theory, the housing conditions case could also progress separately and the issues could be litigated in the housing conditions case. If you believe that a case has been filed in retaliation for a tenant raising housing code issues, retaliation of that nature is not legal in DC, and there is law saying that landlords cannot retaliate against tenants simply for complaining about housing conditions. So that retaliation might be a defense that you would raise in a suit if you believe it's been filed with that sort of motive. I can't think of kind of examples of that, but certainly it's something that you could raise if you believe that the landlord has retaliated in that way. And I'm seeing another question about tenants who don't have written leases but have paid in cash. So in DC, you don't have to have a written lease to have a valid tenancy. You can have an oral lease agreement and it's still a valid tenancy. If that's something that is raised as an initial matter, maybe by the landlord, it might be the type of thing that you have to sort of present some evidence about and kind of argue to the court that there is in fact a lease. So again, this is the type of issue that if we're aware of it at the point of referral, we will definitely flag it for you and definitely kind of give an opportunity to get some guidance on the specific issue from the mentor at the point of referral. But it's not something that comes up too often. And again, if someone has a verbal lease with their landlord and they've been paying rent according to the terms of that oral lease, then they should have every right to bring the housing conditions case. There's no requirement that someone have a written lease to bring a housing conditions case. Oh, and I see Sam has answered the question. Well done, Sam. Great. So I'll just say kind of in closing and give people one more window of opportunity to ask questions if they still have them, that it is really rewarding for me, and I know it's been rewarding for the people that I've mentored, to see a client's longstanding concerns about their housing addressed, and that it can take some pushing at times, and it can take a lot of persistence and sort of like not letting the issue kind of go away as much as maybe the landlord just wants the issue to go away. But it's really so rewarding in the end, and it's really worthwhile. So we really hope that you will all take more than one case, and we hope to hear from you soon. Thank you so much for joining us. And I think I'm going to make sure that there aren't any other questions that I have missed in the meantime.
Thanks, Eleni. I don't know if I'm seeing any more come out. I will just sort of add that I hope you all found today's webinar informative and inspiring in terms of what you can do to help tenants ensure that they and their families have a safe and habitable home. Navigating the court system is difficult enough for unrepresented tenants under normal circumstances. And as we've kind of gone over the court's current operating procedures with remote filings and virtual hearings, pursuing a housing conditions case right now without counsel can truly be daunting. Pro bono attorneys like you can make a critical difference. So we hope you'll take up the opportunity to join us in making justice real. A little bit of background on our pro bono referral process. We generally share cases periodically. If you're interested in a case, you are always more than welcome to email me, Sylvia Soltis. My email address is up on the screen right now. We screen the cases before referring them out to pro bono attorneys. As Eleni mentioned, we assign an experienced legal aid attorney as your expert mentor for each of the cases that we refer out. To be clear, that person is not co-counseling with you. They will not attend hearings with you. They're not going to join in communications with the client, but this person is meant to serve as an additional resource when it comes to proceeding with your case, so that you have somebody that you can turn to when you have questions that go beyond the training materials. We are able to serve as a resource to provide, answer questions, provide sample pleadings, discuss relevant law and strategy as the cases move forward. In addition to all of the, the written materials, the recordings, the samples, these are some of the additional things that we offer. I don't know if and how can we reach out to take on a case? Thanks, Ben. Great question. As I mentioned, you can email me. If you're not already on our email list, you can email me and I can add you onto that list. But I think the most effective way is to reach out directly. It might not always be the most efficient on our side, but I think that what is really helpful is if I know your timeline, if I know your experience level, I am able to identify a case that is suitable for you and that works with your timing, since I know everyone is busy and sometimes has to juggle their own caseload at work. I hope that answers the question.
There were just a couple more questions, I think, in the other chat. So one person had asked about whether the Housing Conditions Court can award damages. And so I answered that they cannot, that if someone wanted to get damages for money damages for damage to property or pain and suffering, they would need to bring a separate civil action. So the Housing Conditions Court does not have the authority or jurisdiction to award money damages.
That's also a great point to, when we talk about screening the cases, I want to highlight that when we refer cases out, we have had conversations with the tenants in advance so that they understand the scope of the representation. We have made clear that the type of pro bono service that they will be receiving, if you all agree to the representation, is one in which you'll be filing in the housing conditions calendar, and we define what what remedies are available there, and we make clear that it is not a compensation. It's not a forum for compensation to them for damages regarding any property or any other type of issues.
Sylvia, can you answer the question about bar status? Do you need to be active in DC?
So yes, asterisk. And what I mean by that is you will need to have somebody, you will need to be paired with somebody or working with somebody that is barred in DC. So, oftentimes when it comes to law firms, very often if you are a newer attorney and your bar status is not complete yet, you would be working under the supervision of a partner or some other individual. For the federal government attorneys that are on this webinar, I encourage you to get in touch with Laura Klein, who manages the federal government pro bono program. She can tell you more about Rule 40, the DC Court of Appeals Rule 49, which governs how you will be entering your appearance, and if and how you can enter your appearance. You'll need a sponsor, but I encourage you to reach out to Laura Klein. I also encourage you to read over Rule 49 that covers the practice of law in DC. And thank you, Laura. I see she's placed her email address in the chat. That's really helpful for federal government attorneys. Laura Klein is a phenomenal resource when it comes to not only answering the questions you might have about navigating your first pro bono case, but also in terms of if you are looking for co-counsel, she can assist you in finding somebody. I hope I've answered all of the questions with regard to the license issue. I know that paralegals are also always interested in assisting on these types of cases. And I will say that while legal aid would not be able to refer a case to a paralegal or a legal assistant, based on, as we discussed, Rule 49, what folks who are interested in taking, assisting on a housing conditions case, what I recommend is connecting with attorneys in your firm or in your agency that might be available to, that they would take the lead on taking the case, and you would be able to assist, whether it be by compiling the evidence or other ways of supporting the case. I'm happy to include Laura's email address in the, I see somebody is saying that Outlook is saying Laura email's address is no longer valid. I will circulate her email address when I send the link to the recording after this training at some point this week, once we have it all edited.
Did someone answer the question about the small claims, whether to bring a small claims case if there's both a rental dispute and damages and housing code violations? Yes.
I think it depends a little bit on what the rent dispute is. So I would have to know a little bit more about kind of what the situation was. There's no reason filing a housing conditions case does not sort of preclude you from litigating other issues in the appropriate forum, which is one of the real pluses of having this kind of special forum. So you can file the housing conditions case and get those issues addressed, and then potentially litigate other issues around rent or other housing related problems separately, and not worry about sort of waiving a claim.
Well, I think if there are no other questions, I think we're ready to wrap up. Thank you again for participating today. We really appreciate you all considering taking on a housing conditions case, and thank you. This concludes our housing conditions training.